Man, bench warrant out of circuit. Perfect.
Bell got picked up. The other girl.
Hello, hello, hello. This clip is thanks to Zach over at LawNerdsUnite, and I found another one. It's tough hunting on the weekend before Thanksgiving. Those of you not from the U.S. who are not familiar with Thanksgiving, it's a holiday we have where we do even less than usual for a week, and then we gather the family around to remember why we don't like each other. It's beautiful.
I think we're ready to go. Good morning, Miss Allen. Can you hear me?
Yes, sir.
This is Judge Middleton. You got arrested last night for alleged violation of your bond. Also with us here on the feed is Paul Gibson. He is filling in for the public defender. He came on short notice. I saw when I came in this morning that you'd been arrested and Bell got arrested.
Yes, sir.
Let's start from the beginning. You're charged in file number 252254FY with assault with a dangerous weapon. It's alleged that you tried to assault or did assault your partner, Bell Ghost, with a shovel. You got arrested and the bond was set in the amount of $15,000 cash or surety, which you posted. One of the conditions of your
That seems a little extreme, even by American Thanksgiving standards.
bond was that you were not to have any contact with Bell. According to the bond violation report, the police executed a search warrant at this house because of zoning issues, 700 Hoffman Street. Is that the big old house with the old Jacobs house?
No, Your Honor, it's not. And she had just showed up literally right when that had started happening. She actually would testify for me on my behalf. She said that she had just showed up.
Well, who lives at that house?
It's not a house, it's a property, and there's tents and
All right, so yeah, people have started to camp out back there.
yeah.
At any rate, you guys were a mess. I don't want to go too much into it, but they found you in a camper in not good circumstances, drugs, and they arrested you for violating your bond condition. They arrested Bell for a violation of Judge Stutzman's order. She also has a warrant out for her from Battle Creek.
Drugs and shovels, what could go wrong?
So now you're not supposed to have any contact with each other and you're both in the jail. You and Bell are not in the same cell, are you?
Yeah, we are.
Oh, you're in the same cell?
Yes, sir.
Oh, boy. The matter is set for a pre-exam conference with Rhonda Ives.
So is it a defense to the no contact order? I mean, they put us in the same cell. We don't have a lot of choice in the matter.
For December 9th.
Or not, but same house. You have to mark.
There was some sort of a camper there?
Yes, sir.
Yeah.
Is that where you were staying?
Yes, sir.
Don't leave it. But we checked whether or not.
Is it hooked up to electricity or anything?
No, sir.
Just rerun.
All right, well, the clear condition was you weren't still have any contact. And you were both there in the same camper and the allegations were not the best. I wish the hearing were sooner. You're essentially homeless and so is she. Now she's in jail and you're in jail and you're in the same cell. How crazy is that? You're not supposed to have any contact with each other.
Judge Middleton's so flabbergasted. All he can do is review the situation. just repeat it all out loud and then just be disgusted with the whole thing.
Mr. Gibson, do you have any input on this?
I guess not right now. Is she, it sounds like she's asking, like she's disputing that she violated the bond condition.
Well, like I said, Belle said she would testify for me that she had just showed up, like, right when the officers had showed up. She wasn't there previously to that.
My original thought was I was just gonna leave you in jail until December 9th. You seem pretty good this morning, but I don't want a housing issue for the jail, and I got both of you in the same cell. You weren't, the place is not good. You're not, it's not, you're a trespasser on there. Who owns this camper?
I do.
Well, how did it, you gotta get it off of there. Have you got someplace to put it?
Yeah. Yeah, I could take it to Jeff Brown's.
Well, he's not doing well, but he did tell me that you're welcome at his place.
Yeah,
I asked him about that. He said, no, she's welcome to be here.
yeah.
This is a strange circumstance. You're charged with an assault with a shovel. And from the report, Bell didn't want to cooperate with it in the first place. That's not the problem. The problem is methamphetamine or opioids. I'm gonna find bond violation and give you 1 day credit 1 day. I don't want you and Bell sitting there in the same cell. You're gonna get out of jail. I also don't want you to forfeit your $15,000 cash or surety bond. You can't have contact with each other. She's gonna be in jail for a while. Judge Stutzman's got a hold on her and so does Calhoun County. But I'm not accomplishing much if I got you guys in the same cell. You didn't really do anything, but you got to get your stuff out of there. Also, if I leave you in jail, they're going to haul all your stuff out of there and take it to the dump or something. You need to get out, get that property out of there. You're going to lose all of it.
Yes, sir.
All right, Ms. Ghost, your next hearing is set for December 9th. Bell, are you acceptable with me making a finding that Mandy, that you had contact with Bell in violation of the condition of your bond?
I'm sorry, what was that?
Are you acceptable with me making a finding that you violated your bond by being in that camper with Bill?
I mean, yeah, sure, I guess,
All
yeah.
right, and I guess the offer was I'm gonna let you out of jail. But I don't want you sitting there in the same cell, and I don't want an administrative headache for the jail to figure out what to do with both of you. So I'm letting you out. I want you to go back there, get your stuff and get out of there before the
Yes, sir.
city takes it to the dump.
Yes, sir.
All right. Good luck.
Can I just add one thing, Your Honor? I also know that Mandy Allen is scheduled for a status conference in Circuit Court on Monday, December 8th at 9:30. So she should make a note of that.
They didn't cancel it? They added to it.
Yeah.
All right, you got that, Mandy?
Yes, sir.
All right, you got one hearing Monday and one hearing Tuesday.
Thank you.
Those pants are kind of droopy. They need better lady pants for the jail. All right, you're good to go.
Thank you.
Put those green jumpsuits on. She is another sparrow in a hurricane. The prosecutor isn't here. I suspect they probably would have objected to her being released, but nothing really was going on other than the fact that, anyway, I stated my reasons. This is to help the jail. She's a danger mostly to herself, and I want her to get her property off of that property. So thanks for your help on short notice, Mr. Gibson.
Thank you.
Lori Allen is her mother. And so they've both been struck.
We're ready yet?
Yes, Your Honor.
All right, looks like we're gonna do Johnson and then Loomis. You can go ahead and let everyone in. Okay. All right, what's the state feels appropriate?
Thank you, Your Honor. For this defendant, the state's seeking $100,000 with no 10% cash alternative. We're asking for DAS supervision along with
I don't know. Somebody sent that to me. I don't even remember who now.
a no contact order with the victim. We are also asking for no firearms or weapons, as well as house arrest and GPS prior to release. That is based on several factors. Number one, the underlying violence outlined in the probable cause
Yes, I have another holiday love story for you.
declaration. In addition to the defendant's very high MPRA score of 13, you can see he got the maximum number of points for prior violent criminal convictions. He was paroled from his last felony in March of 2024. That was a DUI third out of our second judicial district court. When I pulled the pre-sentence investigation from that case, showed him to have 2 felonies and 22 prior misdemeanor convictions. 2 of those misdemeanor convictions were from 2022. They are those prior domestic batteries that were discussed in the probable cause declaration. One was out of Sparks Justice Court, or it looks like they were both out of Sparks Justice Court. He had issues with being out on bail in that case. Looks like he was revoked no less than 3 times on those cases. In addition to that, he has a DUI, and it is this, I think also mentioned in the probable cause, same victim as we see here. He had a misdemeanor DUI in 2019. He was released on supervised bail. It was later revoked. He was given probation on that case. It was also later revoked in 2020. He has convicted.
Don't worry. He's really a good boy.
Misdemeanors for trespassing and destruction of property that year, another DUI in 2017. He's got a felony conviction in 2014 for intent to utter a fictitious bill. He received diversion on that case originally. He was removed from diversion and sent to prison on that case. And then he's got another misdemeanor conviction for domestic battery in 2012. He has a assault conviction out of Reno Justice Court in 2011, along with possession of drug paraphernalia. And then finally, another assault conviction back in 2007. We were able to speak to the victim, who I believe is present here today. She said she is not seeking a no contact order, and that she is not in fear of the defendant. She said he's a great guy with a really good job and a good provider. She says he doesn't have any weapons. But unfortunately, I disagree with the victim. We are asking for a no contact order based on the safety of her and her children. This, as you can see from the probable cause declaration, the victim was somewhat hesitant to report what happened in the first place. We know one of the children came forward and reported to police that the defendant had struck the victim in the face, and that she had injuries as a result of that. So based on his criminal history, his compliance issues, and obviously the violence in this case, we do believe a higher bail is appropriate and are seeking that $100,000 with those conditions.
All right, thank you, defense.
Judge, that would be a de facto hold on Mr. Johnson. We're seeking for an OR release in this case, maybe $5,000 bondable. This is one of the rather strange PC in that it seems that there was a fight earlier in the night in which other women jumped the victim in this case. And there was an argument between Mr. Johnson, and this is all in the PC sheet, and her about what had happened and whether or not he had let it happen or seen it happen. And the officer notes that the victim is actually striking him in the face when the officer sees her. He actually witnesses that event. I understand that the children may have seen something or may have seen her after or heard something. I'm not clear about that yet. This really looks like a case that needs to kind of go to trial and get figured out. But in the meantime, I don't think Mr. Johnson should be held in jail while we figure out what actually took place in this case. I understand the state can proceed on charges without her wishes or beyond her wishes, or against her wishes, that is. But given that he's been here for 19 years, he's got a job, he's got kids in the area, we're asking for an OR here or $5,000 bondable. He's not a threat to run. Although he has a history of violence, he does not have a history of taking care of business. He does show up to court and he will do as directed. We're not opposing any of the conditions as set by the court or as requested by Ms. Casso, Chief Casso, excuse me.
All right, let's go ahead and hear from the victim. Just go ahead and unmute yourself and you can let me know what your thoughts are.
Get ready. This is everything you think it's going to be.
If you're having problems, go ahead and chat my clerk. Otherwise, we're going to have to move on.
Hello, can you hear me?
I can hear you. Go ahead. What would you like to say?
Hi, Your Honor. Good morning.
Good morning.
So this whole situation, it really is a real misunderstanding. I understand, like, I don't know, it kind of hurts me, like, they're bringing up his past and, like, looking at his past and stuff, but Deontay's been doing really, really good, like, very good. He's been staying out of trouble, staying out of way. He does have a really great job that he end up receiving. And if he doesn't get to work, like, we will even lose our home because we had just moved. He has never, ever put his hands on me at all. And with the whole situation that happened, it didn't even happen here in the house. And it had nothing to do with me and him. I locked him out. I was upset. You know what I mean? And I was more of like the aggressor, and, you know, we were bar hopping and things took place with somebody else. And I told them that, and I don't understand what is happening or why it's happening. And it does hurt because I know the truth, and I know that that's not what happened. And he doesn't deserve it, to be honest. He's really great to me. He's really great to his children, my children. He's very enrolled, like, with the football, the travel team, just his kids. He's wonderful, and he's changed a lot, and he's trying to do the best that he can and staying out of trouble. And we just happened to go out one day, and end up getting into a situation. Well, I did. So I just asked, I'm not scared. I'm not in fear. Neither are my kids. Everyone's just really upset. I was upset, and
exciting and new.
And I do apologize, especially Deontay. Like, I hate this for you, and I just don't want to see him in trouble for something he did not do.
All right, thank you. Thank you for being here. I know this puts you in a very difficult position. I wasn't there. I don't know what happened. I'm in a position to take a sworn declaration from a peace officer who was there, whose job it is to investigate. And we don't, blindly accept any statements made, but that's the evidence I have today, and it does support probable cause for this offense. The next decision I have to make is whether or not the state has shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant. And I know it bothered you to hear the prosecutor go into detail about his prior criminal history, prior crimes of violence, prior failures, both on crimes of violence and driving under the influence charges with our courts. And you believe he's a different man than what that history portrays. But all the science says the best predictor of future behavior is past behavior. And so he will have an opportunity to make a new history for himself. And once these things get further away from him as far as years in his criminal history, then courts will not use it against him. But right now, these are the greatest predictors of what he's likely to do. And again, I know it's a different person than what you say you know. But I have to go with what the evidence suggests to me in this case. And so,
please don't do this. We're gonna lose everything. Like, I understand. I'm sorry. I'm not trying to talk over you, Your Honor, but I know, like, this is the thing, and this is the thing with the system, because I am myself of a person that has a past, and I have changed my life around. I got my record sealed. He has changed. He's not who they even saying he is. It's not. I promise you. He has an opportunity with a great job. He goes to work every day. And if he doesn't even go to work, he will lose his job. Then what? It kind of puts him in a situation. I don't want that for him. Or for us, we could lose our home. I'm begging you, and I swear, this is not what happened. It's not what happened. Please just take mercy and just at least at trial, okay, whatever we got to do. He will not run. You can't judge. Please don't judge. Give him a chance. Please.
so I believe in chances. I believe in second chances. I believe in third chances. And the hardest part of my job is either on the civil side, kicking people out of their home, or on the criminal side, putting someone in jail or keeping them in jail. Because I have done a lot of research, received a lot of education on the collateral consequences. I was just reading this weekend on best practices on these types of cases, and this very situation that often occurs where the victim is re-victimized by the financial hardship caused by incarcerating the breadwinner. And so while I've never been in your shoes, I have done everything I can to try and appreciate the situation that you're in and the consequences of my decisions. Luckily, the law says that incarceration is the last resort. And so it's consistent with what, my personal feelings are in this situation. But we use a scoring mechanism so that the judges are not, subjective. We're not going on our fears of And that objective tool indicates that the defendant has at best a 50 percentile of being successful.
More than that. More.
In this
More.
case. I know that's what you think, and that's great that he's got somebody supporting him, but that's not what the evidence says. And then I don't have any evidence that's been presented to me in this case or in all the years I've been doing these cases that shows that any of the conditions available to me will minimize that risk. And so I have no choice in this matter
Please.
to set
Please.
bail outside the defendant's ability to make it. It'll be set at $200,000, no
Oh my
contact.
God.
Separate criminal offense pursuant to NRS 178-4845 for maximum 120 days firearms.
That is the problem with the
Next court date,
system.
December 1st at 9
That is.
a.m. Bail
The
laws,
system.
no court appearances.
John, what is your
That concludes this
spell?
matter.
24 hours being released.
Loomis and then Mattson.
Upon being released, you have to make contact with DAS. Sign right here.
And sir, just so you know, DAS will be gone if you do post that bail by January 1st. So you'll be checking in with this court for your court dates. Thank you. Loomis and then Mattson.
Well, Loomis.
She just needs an Italian sausage and a corn dog, and that would fix her right up.
Ah, there you have it. Another Law Talk with Mike. Heartwarming Thanksgiving special. That's all I could find. That's all I could find today. I'll take it. Thank you all for coming out. I will see you all soon.